Hello, and welcome to Stowe Talks, a podcast designed to support people going through a relationship breakdown and all the challenges this brings. I'm Matthew Taylor.
And I'm Liza, family lawyers at Stowe Family Law. And today we are joined by Andrew Powell, one of the country's leading children's law barristers from 4PB, who specialises in surrogacy law. So hello, Andrew. Welcome to the Stowe Talks podcast. Thank you so much for joining us. Could you start off just by giving us a bit of background about yourself and how you came to your current position and how you came to be doing surrogacy work?
Well, thank you very much for having me on your podcast. Delighted to be here. My foray into the world of surrogacy is quite long-winded, actually. I'll try and keep it as brief as I can. But my route to becoming a barrister was quite an unusual, well, not that unusual nowadays, but I read social anthropology at university a long time ago. I won't say how long ago. And that was all about kinship and looking at different ways of how people view family, well, not just families, but different ways in which people see the world. And one of the topics which we covered was about surrogacy and how new reproductive technologies have really fractured how we look at what makes a family. And as a consequence, the law and social policy doesn't often reflect those advances in medicine and science. So I was really kind of interested in it from an anthropological perspective. And despite doing an anthropology degree, I knew I wanted to be a barrister, but I wasn't really sure what area of law I wanted to go into. And so I did my law conversion and started doing, work experience as everybody does. And I knew I wanted to work with people, so family, crime, immigration, employment were kind of areas that interested me. And so I applied to kind of, mix common law sets for pupillage across the country. And I got offered, I was quite lucky, I got offered 2 chambers, and I decided to go to 4 paper buildings, as it then was, in 2007, 2008. And so I just became a family specialist, but I still had a real interest in surrogacy law. And in 2013, I applied to do a Pegasus scholarship, which is a scholarship that is offered by the Inner Temple, where they allow newly qualified barristers under, I think it's 7 years call, to go to another jurisdiction to learn about the law in that particular country. And they have pre-arranged programs where you go to, Washington, DC or to New Zealand to shadow somebody in the Supreme Court or whatever like that. But I went with a pre-arranged plan saying, look, if you give me this scholarship, I'd like to go to Los Angeles and spend 3 months at a firm in LA, which sounds a bit like a party, but I did learn quite a lot. And so that kind of, again, galvanized my interest. And I was fortunate enough already to have expressed an interest in this kind of area of work. I'd already done a few cases, some of which were reported. And so that was then my platform from which I think I kind of became more well-known about that kind of area of work. And I had a blog while I was in LA called Wig and Gown in Tinseltown, which one of my friends coined. And so that kind of gave me a bit of a publicity of somebody who did this area of work. And so it's kind of just grown from that, really. And I think it's also probably coincided with it being pretty crudely a growth area in terms of our work as family lawyers. So I've been quite fortunate in terms of the timing, really.
Yeah, I guess that kind of covers the span of it going from, we'll maybe talk about the numbers of kind of surrogacies per year and parental orders per year in a little bit, but that's the kind of covers roughly the span of it coming into consciousness and there being a drive behind kind of it becoming a work area that people are familiar with. For anyone listening today might think that, Matt's asking some very obvious questions. He doesn't know anything about this. And they'd be absolutely right, because you talked about it being a growth area and fairly new development in the law. It's not something that every family lawyer does. I don't do it. I know, obviously, Andrew, you're a specialist. Lisa, you're sort of leading light at Stowe Family Law of people who do this. So for those people like me who are coming to this totally new and don't really understand it, before we get into the really nitty-gritty of things, should we just take a step back and run through, what does surrogacy involve? Maybe not from a legal perspective so much as, what's the definition of surrogacy? What's the actual practical process involved?
I think that's a really great question, Matt, because I think sometimes it can be misunderstood what it is. And so surrogacy, the basic way of looking at it is when a woman or a person carries a child with the intention of giving it to somebody else. That's essentially what it is. But there are two types of surrogacy. There's gestational surrogacy, which is fairly common, and that's the situation whereby an embryo is transferred or placed rather into the uterus of the surrogate. And so the surrogate's not genetically related to the child. And once a child is born, the child is given to the intended parent or parents. And of course, that embryo can be created via, or through IVF, but can be either using the gametes of the both intended parents or just one of them. They would qualify for parental order on that particular requirement that one of them has to be genetically related. But it is increasingly common, I'm finding, to see people who use double donor embryos where the intended parent or parents have no genetic relationship to the child. So it's, for example, happened in another jurisdiction, and the surrogate gives birth to the child and they take care of the child. There's also traditional surrogacy, whereby it's the egg of the surrogate that is used. So that person has a genetic link to the child. But again, same principle, they carry the child and they give the child to somebody else. It has to be through artificial insemination of some form for it to be surrogacy. And generally, what is difficult, why it becomes a kind of a difficulty in this jurisdiction, is that it's a common law principle. It's now also enshrined in statute, but it's a common law principle that the woman who gives birth to a child is always the child's mother. And that's regardless of genetics. It's also regardless of any order or judgment obtained in a different jurisdiction. So if you have a situation whereby you have a couple who go to California or to another jurisdiction, it's both of their gametes that are used in the case of an opposite sex couple, and the surrogate gives birth to the child, gives them the child as is planned post-birth. They obtain, in fact, in places like states like California, you can obtain what's called a pre-birth order. So normally obtained at about some point in the third trimester, where the Californian court declares the intended parents as the parents once the child is born. Those parents are registered on the Californian birth certificate, but that's not recognised as parentage in this jurisdiction. And it gets even more confusing, because if the surrogate is married, then her husband or spouse is the child's legal father, which is, of course, is slightly at odds with like where the science is, because that's not what most people on the ordering down on the street would think. That's a bit odd that can be right, but that's how the law is currently. So in short, it's a woman or person who carries a child for somebody else with the intention of giving it to them to be there for them to raise the child.
So you talked about, in some of those examples, at the start you said about having a parental order, and I guess this is, from my limited knowledge, this seems to me to be the crux of the issue. Maybe you could just unpick that, what a parental order is and why it's important for anyone who is considering going down the surrogacy route.
So a parental order is a bespoke order that transfers legal parentage to the intended parent or parents from the surrogate and or their spouse. So it's a bit like an adoption order, in the sense that it is extinguishing permanently legal parentage or parenthood and transferring it to the intended parent or parents. But it's very different to an adoption order, because an adoption order is a particular order for children who are unable to remain with their birth family for whatever reason. And the adoption order is effectively replacing their parenthood, the child's parenthood from birth. It's replacing. Whereas with a parental order, it's reflecting what was always intended. And of course, there are criteria that you have to meet to qualify for a parental order. And that is your kind of like your checklist to make sure you are eligible for it. And if you don't meet the criteria, then you don't get the order. And I'm sure we'll come on to it at some point, but there've been in the last decade, there's been I would say, a wholesale erosion of the statute, and the main statute is the Human Fertilisation and Embryology Act 2008, and it's section 54, which contains the list of criteria that makes a person or a couple eligible for a parental order. So the obvious one is the first one, which is it has to have been carried by somebody else, another woman, by artificial insemination. So if there's been sexual intercourse, that obviously doesn't qualify. That's a different scenario, more familiar to family lawyers. The applicant or the applicants have to be over 18. That's really straightforward. They have to be either married in a civil partnership or a long and enduring family relationship. If it's a couple, that in particular has been really, really strained and stretched. I should say stretched, not strained, but stretched in case law in the last decade, because marriage is quite straightforward to prove. You can say, well, as long as there hasn't been a final order on the disillusionment of a marriage, then you're still married. And same with a civil partnership. But there have been a number of cases where, on the enduring family relationship criteria, where the couple have barely been a couple, but there's been a joint intention for them to raise a child, and the court has applied ECHR type principles under Article 8 to make sure that you construe some form of family life. So, like, one of the really extreme examples, a case called Rie from 2020, which I was in, whereby the couple, they've been in a relationship very briefly at the very beginning. They had a child through surrogacy, and using both of their gametes, and prior to the birth of the child, they separated. And so when they eventually applied for a parental order, I'm giving you the abridged version of this, but when they eventually applied for a parental order, the father wasn't actually having any contact with the child. The child had barely, hadn't even been to his home. So to say that the child has their home that's not the way. To say that there's an enduring relationship and the child has a home with both of them was quite far stretched, but the court was able to use Article 8 principles to interpret it that there was an enduring family relationship, because they had a joint intention to raise his child together, and he was going to build up his contact. One of the other criteria is that when you make the application and when the court makes the order, the child's home has to be with the applicant or the applicants. And again, that sounds quite literal. If you make the application today, that address has to be 21 Acacia Avenue, and ditto when the court makes an order in a few months' time, the same address. But in those circumstances where you have a couple who have separated, again, the court has, deliberately interpreted the word home quite broadly and quite purposively. And attached to the home requirement is that one of them has to be domiciled in the United Kingdom or the Channel Islands. That's a finding of fact which the court has to make. A critical component is that the surrogate has to consent to the making of a parental order, and that really is the bedrock of the statute. If you don't get consent, the application comes to a complete halt, and the consent has to be given freely and unconditionally with a full understanding of what is involved. And consent can only be obtained 6 weeks post-birth for it to be valid. So there's a kind of a period postpartum where it wouldn't be valid. So it has to be beyond the 6 weeks. And unlike and a lot of these statutory requirements and the regulations around surrogacy sometimes parallel adoption, because it's very similar in terms of the transformative element of the order that's being sought. But the requirement under the current statutory framework is that if you don't get consent, you don't get your order, unless it can be said that the surrogate can't be found or is incapable of giving consent, i.e. she lacks capacity. Some kind of something has happened to prevent her from being able to give consent. And so with adoption cases, the court has the power to dispense with the birth parent's consent if it's in the child's best interest. That doesn't happen in adoption. So unless you meet the criteria, which I'll come on to in a second, about not being able to find the surrogate, if the consent isn't unconditional, you don't get your parental order. So, for example, there was a case recently called Re-C that went up to the Court of Appeal, and I think it was handed down earlier this year in January. It was heard in November 2022, and it involved a case where the surrogate, it was a domestic arrangement that came before a circuit judge, and the surrogate basically said, I'll give my consent to the parental order if I can have a child arrangements order so that I can continue to see the child on X amount of time. The judge accepted that as her consent, and the surrogate later went away, got advice, and successfully and understandably won her appeal because it was given unconditionally. She was giving it on the condition she got a child arrangements order, so the Court of Appeal said that's not a clear consent. And so that becomes quite difficult. But you can get around the consent part, as I say, if you can't find her, and she lacks capacity. So, for example, a lot of the cases involve Ukrainian or Indian surrogates from the early 2010s, where due to global movement, or displacement of people, you're unable to find the surrogate, and so you have to kind of show to the court that you've exercised or exhausted, rather, all possible avenues to find her, all reasonable avenues. And there have been a couple of those cases more recently involving Ukraine, particularly in light of the war, where people have been displaced and it's difficult to find people. And then the last kind of element is a commercial element, so that you can, in this jurisdiction, the only surrogacy that is allowed is altruistic surrogacy. So the Surrogacy Arrangements Act 1985 prohibits commercial surrogacy, and it also prohibits brokering or negotiating a surrogacy contract, as well as making clear that a surrogacy arrangement or contract isn't enforceable in this jurisdiction. So you can't have specific performance to make somebody comply with a contract. It just doesn't work. So only altruistic surrogacy is available here, and the court has to be satisfied that only reasonable expenses have been incurred. So if it's a domestic surrogacy, the surrogate can be paid her reasonable expenses, obviously related to the surrogacy, and the court also has the power, because it recognises that it can be a commercial enterprise in other jurisdictions, such as certain states in the US. And the court has the power to retrospectively authorise those payments so that it's effectively allowed. So that's a long trawl of what the criteria are for a parental order.
Yeah, it's really interesting as well, because some of those are really easy, aren't they? When we have clients come in for initial appointments, some of those things we can just tick off the list very easily. We'll be able to show it, it's not a problem. And I guess I'm really pleased that most of the cases I deal with are fairly straightforward and are agreed and are approved without any problems, because, we make sure that we can go through that checklist way before implantation takes place, and that, we've got a really strong application going forward. From those criteria, I mean, you already highlighted that a few of them can pose more difficulties than others. Which one? Because obviously you're in court more, which means that by being in court, you're dealing with more of the cases that are having problems, shall we say, or have become more complicated. Which of those elements do you think poses the most problem for people? And is there anything that they can be doing, or, people that are thinking about surrogacy now, is there anything that they can be making sure that they do or think about so that they're not in that camp?
Really good question. I mean, things like home, defining what home means if the parents have separated is easily got around. Same thing for enduring family relationship, or status of marriage. And domicile is effectively a finding of fact, which the court has to be satisfied about. Whether you have either domicile of origin or domicile of choice, i.e. you were born here, live here, have all your interests in this jurisdiction, then you have domicile of origin here. And of course you can lose it if you were born somewhere else and then you establish permanent roots to anchor you here, then you've got domicile of choice here. They're all quite fairly straightforward. I think the biggest issue is probably consent. And I say that quite cautiously because I don't say it in a way in which to say that consent should just be forgotten about. It's obviously quite important in terms of where the law is at the moment. And I think there have been a number of cases, for example, where even though the child has been in the care of the intended parents, the consent hasn't been forthcoming. And sometimes there can be a myriad of reasons for that. But one of the biggest one of the biggest barriers that I think leads to the consent problem is where you have surrogacy arrangements that are conducted at arm's length. And so if you don't know the surrogate, you've not met her, and these tend to happen in different jurisdictions, and they're often, not always, but they're often in low-income countries where the surrogacy arrangement's negotiated through a clinic or a third party. And in those circumstances, if you've not met the surrogate at an arm's length relationship, sometimes how those things operate is that once a surrogate has given birth and the child has been placed in the care of the intended parents, they then disappear. And then trying to locate the surrogate becomes difficult. And so I think intended parents have to really do their due diligence before they embark on these arrangements, because you're bringing a child into the world and you want to make sure that you are afforded, and the child is afforded, the maximum legal protection, which is you being recognised as their parent. And so if you go to jurisdictions where it does appear to be that you're unlikely to be able to have that kind of, I'm not saying they're going to necessarily want to be the best friends with the surrogate, but at least knowing who they are, knowing basic things like their name, whether they speak English or not, all these things are going to be necessary, because for the consent to be valid, if it's in a jurisdiction or if the surrogate doesn't speak English is not her first language, you're going to need to make sure that everything's translated so that she can read the consent and give the consent properly. In domestic cases, it can get a bit more trickier. Well, perhaps not as tricky, but the intended parents can still find themselves in the same difficulty if, for example, there's a breakdown in the relationship between the intended parents and the surrogate. That can sometimes be a reason why the consent might not be forthcoming. And so it's just being alive to those things. And I suppose one of the things that one has to take into consideration, I would imagine, is looking at that matching process and working out where everybody positions themselves. Because if you don't get the consent, if you can find the surrogate and they're there, but they're saying, I don't want to give consent, it's pretty much game over. And the only way you can get round the consent issue is if they can't be found. And that tends to be in other jurisdictions, and as I say, often in low-income countries. And so intended parents should be alive to the fact that if there's limited contact with the surrogate, that might be a problem. That should be I'm not necessarily saying it's a red flag, but it should be something which should be a cause for concern. And they should perhaps exercise caution, because they want to kind of really get the particulars about, after 6 weeks, we need to get this particular form. It's called an A101A form. And when it's signed, this is the consent form, and when it's signed outside of the UK, it has to be signed and notarized. And so, before you even do embryo transfers, they need to be asking these questions to the clinic, saying, well, post-birth, we'll need to get this signed. Does the surrogate understand the importance of this? Where does she live? What's her address? All those kind of things which seem like common sense questions, but often don't get asked. And I think, and it's not just this particular limb of the criteria where things can often fall down on, but sometimes there is such an understandable desperation to become parents that sometimes those kind of due diligence elements aren't thought about, and that it might cloud people's judgment. But it can be done right if you think about it, what you need to do, because it's a big deal.
I think the emotional element of all of that, and you talk about that desperate desire to be a parent, and if you've been unable to conceive or for whatever reason, you're going down the surrogacy route, and that's a big decision. And then to go through the process in the knowledge that all the way through consent could be withdrawn. up until, that consent may not exist at the time of them making the application for the parental order, up to 6 weeks after the birth. It must be incredibly stressful, because I can imagine it from both parties' perspective. Intended parents are thinking, "Oh, I hope this is going to be okay. So I hope this is going to be okay," for months and months and months, and feeling that you're okay, and then suddenly the rug gets pulled under you. But for a surrogate, you go through, any woman who's gone through a pregnancy, you find that it's a difficult and emotional process, and there's some bonding time that there, isn't there? So that element of consent is, and the fact that you said before, there's no specific performance, you can't have an agreement that's enforceable and say, well, you sign this so you have to give the child over. It's it really, I can see lots of problems. So what do you make of the current state of the law? It seems that you sort of talked about the way that the court's having to stretch certain definitions, talked about maybe in certain cases the consent thing might not be satisfactory. I mean, is it still fit for purpose? And if not, what needs to be done to change it?
Well, the one thing I would actually just say, Matt, about the consent point is that I think, obviously, you could have already alluded to it, but of course, it's a bit like speaking to an oncologist who only just sees really sad cases. Most surrogacy cases go on without being reported, and particularly domestic surrogacy cases, the case laws are actually, there's not very many cases, because the domestic ones get dealt with in the magistrates' court, and they rarely go up to district judge, circuit judge level, let alone high court level. And there are a number of not-for-profit organisations in this jurisdiction that operate quite well, where there are more success stories than there are ones where there are difficulties. Like much more, like pretty good records.
Right, sure.
And I think it's broadly the same in terms of, it's more difficult to measure it internationally. But I think, the data and the research is that most people who want to be surrogates because they elect to do it of their own free will. And that can be slightly more complicated where it's a low-income country where there might be a concern about possible exploitation. But generally, I just want to kind of make sure I'm not giving the wrong impression that to say that everything ends up in a court case, because it doesn't. But actually, largely,
yeah, we don't want to be absolutely terrifying everyone. And apologies if I was doing that. You kind of went through it, and I thought, oh crikey.
No, I mean, certainly the vast majority of the cases that we deal with, the parental order is dealt with without any issues whatsoever. And they go through nice and smoothly. It's why it's quite interesting for me to speak to Andrew, because obviously he does see it from the other end, in that he does see the ones that unfortunately don't, but certainly they are in their minority. The vast majority of the time.
Sometimes I have to have my own reality check that it's actually the iceberg stuff. But so your question about the current situation, the legal framework, whether it's fit for purpose. I mean, the one thing I would say is that, the law concerning surrogacy in this jurisdiction is approaching being 40 years old, because the Surrogacy Arrangements Act is a 1985 Act, which came on the back of the Baby Cotton case, where a surrogate, Kim Cotton, had a child through surrogacy for an American couple. It was all perfectly above board, but there was no legislative framework to decide what should happen. And I think the child was made a ward of court initially, and then eventually the child went to live with the intended parents, I think a US couple. And that brought, as a bit of a kind of a knee-jerk reaction, that brought around the Surrogacy Arrangements Act, which then prohibited it on a commercial basis. And then there was the 1990 Human Fertilization and Embryology Act, which was a product of the Warnock report. So Baroness Warnock looked at it in the 80s, and then what came about was the HFEA 1990. So that created parental orders, and parental orders at that stage, of course, were only available for married couples. Civil partnerships weren't even a thing, let alone having it for same-sex couples, let alone having it for people who might be cohabiting or in an enduring relationship. And then the 2008 Act, which came into force in 2010, then tried to bring it up to speed by saying, well, hang on, we can have it in people who are in an enduring relationship, but it didn't allow it for single people. It was only through a declaration of incompatibility in 2016, in a case called ReZ number 2, where a single man who met all of the criteria but for not being a couple said, well, hang on, it's discriminatory and a breach of my Article 8 rights to family life not to be able to apply for a parental order. And the government in that case conceded and said it's a breach of Article 14 rights on the basis of it being discrimination. They didn't say it was an Article 8 breach. And that then brought about, as a result of the declaration of incompatibility, the government were then obliged to change the law. So the law changed in 2019 to allow single people who are genetically related to the child to apply for a parental order. The biggest thing that's happened in the last 3 or 4 years is that the Law Commission, I think in 2018, announced that it was going to look at surrogacy. And there's a really, I can't really remember the quote, but there's a really great quote from the commissioner, one of the commissioners, Professor Nick Hopkins, who says, you know, surrogacy is a legitimate way of forming families, and it's important that the legislative framework is fit for purpose and meets the needs of modern society. And so they did a really long analysis of it. They looked at all the key stakeholders, surrogates, lawyers, intended parents, judges, everybody, to try and propose a new surrogacy law. And that came out in March 2023. I think there's an interim report a few years ago, but the final report came out in March 2023, which basically recommended a new pathway for surrogacy, that intended parents would be recognised as parents at birth if certain criteria were met. But it only worked for domestic. It's only recommended for domestic cases. So if you're an intended parent or parents going to another jurisdiction and you have a child through surrogacy there, you're still obliged to go through the normal parental order route still. So nothing really changes for you. They've recommended that the jurisdictional criteria of domicile is changed to being domicile or habitual residence, which for lawyers will know that habitual residence is an easier test to satisfy than domicile, which is much more difficult. And they've recommended that consent can be dispensed with if it's in the child's best interest. So that would be a complete shift to what is currently in place. They've also made recommendations about how reasonable expenses are paid, and they're doing a kind of a clear schedule about how that operates. And I think whilst it's moving in the right direction, I don't really think it kind of tackles a lot of the issues. For example, it doesn't really address the international element, because we've got a framework at the moment for adoption where if you go to a particular country to adopt and it's on a particular list, then it's automatically recognised in this jurisdiction. That would make sense with surrogacy. But that hasn't really been considered. When the Law Commission publishes a report, the government are obliged to report within, I think it's normally within 6 months. And so the 6-month window was in September. And it was actually only last week that they announced what their response was. And there was a APPG on surrogacy, so an all-party parliamentary group on surrogacy that's been in place for, I think, since 2018. That's kind of been working alongside the Law Commission. They kind of like complement each other's work. And obviously that's quite important because it's got parliamentarians who are looking at it as well. And one of the Law Commissioners, Professor Gillian Black, had the response from the government last week at this meeting on the 8th of November. And the government basically said that I'm looking for the quote on my phone, and they basically said they're not taking it forward at the moment. And the parliamentary time doesn't allow us to take it forward at the moment. And so that's perhaps not that surprising, because when you look at the political cycle, there will be an election in the next 12 months or so. And so no one really has the appetite to pick it up. And so it's likely, if it's looked at, it will be a new government looking at it. And so we're lucky in one sense. So I don't think the framework works well at the moment. For example, there are, the case law just keeps expanding and expanding for where it doesn't fit. So, for example, there have been cases, very tragic cases, whereby a child has died before a parental order could be made post-birth, and for that family not to have an order that says that child was their child legally, that's devastating. That's quite shocking, actually. And if you compare that to, say, stillbirth, or stillbirth, obviously post 24 weeks, there'd be recognition of that child, and that's quite important. And not to have that is quite a really sad indictment, that you can't, even the law can't really get around that. Well, there might be some changes to that, but that's something that, for example, the Law Commission have recommended. They've said that in the event of a child dying before an order can be made, the order can be made for a dead child. So I think the Law Commission's recommendations, they're better than nothing. They move it forward. They bring it up to date. But I think it could have gone further. But C, they're only recommendations, and it's only once somebody or a group of people in Parliament decide to say, well, actually, this needs to be looked at before we're going to get any change. And who knows when that could be. We all know as family lawyers how proposals by the Law Commission can sit on shelves for almost decades before anything's done. So watch this space, that's all I can say.
If I can just take you back then to, we were talking about the difference between international and domestic surrogacy, and how different jurisdictions deal with surrogacy. I don't know about you, there seems to be new jurisdictions popping up left, right and centre that, people will say, oh, I'm looking at going here now, and you think, oh, I've not, that's not one that's been on the table before. What advice would you specifically give to people that were, I hate to use the term jurisdiction shopping, but perhaps were considering different jurisdictions for whatever reason? I often hear from intended parents that one of the reasons that they don't want to go ahead in the UK is because there's a lack of surrogates to a certain extent. Sometimes the waiting lists can be quite long with the not-for-profit agencies, or that it's the not being able to get a pre-birth order. Often they'll want to go to a jurisdiction where they can get that pre-birth order. But what are the things that they really need to be thinking about when they're looking at going abroad for surrogacy?
Well, I certainly agree with you that I see that too, that you get new jurisdictions popping up all the time. I think, as we already touched upon, again, it's establish what kind of relationship it's going to be like with the surrogate, because at arm's length relationships need to be approached with caution, because that might mean there might be difficulties obtaining consent. But more broadly, they need to think about things like immigration points. So, for example, how are they going to get back to this jurisdiction? What's the wait time? So, children who are born in the US or Canada automatically acquire citizenship in that jurisdiction. So they get a passport, so they can get back. But how are you going to apply for some form of travel arrangement to get back to this jurisdiction? So that might also mean taking advice from an immigration lawyer either in this jurisdiction and or that jurisdiction. How are they going to look at matching? Like how does that all operate? Because some jurisdictions where surrogacy arrangements pop up and they're not established, it's important to know what is your legal status at birth. Do the intended parents have legal status at birth? Because again, that might be something which they have to wait for, because if there's going to be a court procedure post-birth and you're in another jurisdiction, how does that work? They really need to kind of contingency plan, because a lot of the cases that I'm involved in, things happen that weren't expected. For example, we say it now, but we perhaps don't think it's now longer unforeseeable, but a global pandemic happening. What happens in those circumstances when you're then having to try and get across borders? Like, how does that work? War. What happens if a war breaks out? So if you're going to a jurisdiction that's politically unstable, that might be problematic, and that might be worth thinking about. I've seen cases where I mean, one of the considerations a court has to look at is whether, when they make a parental order, is whether the intended parent or parents have acted in good faith, and whether there's been any breach of public policy. And if they're going to a jurisdiction, for example, where, okay, surrogacy might be popping up as a new market, but if it's prohibited, but they're still doing it, that might be problematic. So, for example, there are some jurisdictions where surrogacy is permitted, but it's prohibited if you're a same-sex couple, if you're LGBTQ. So that's a consideration they need to take into account as well. So they really need to do their homework. If it's a new jurisdiction that isn't very common, they need to really establish what their position is to enable them to get back home safely, what their status is in that jurisdiction, how easy it's going to be to obtain the surrogate's consent post birth, and to look at how the surrogacy either agency or clinic treat the surrogate. Because one of the things which the court is going to want to look at when it's considering the parental order is what steps did they take to satisfy themselves that this was going to be okay. Because one of the things you don't want to happen is that you get a situation where the surrogate is like, well, I don't want to give my consent because I was treated really badly and I didn't know about X, Y, and Z, and I didn't realise it was going to be a same-sex couple. All these things can become quite difficult. So they really need to kind of basically do their homework and exercise extreme caution.
And what's the best way for people to do that homework? Because it sounds like there's a huge amount to consider, and perhaps Lisa, you've got some tips on this for clients who come to see you. Where should people, if they're listening to this and thinking, okay, that's giving me an overview, and there's a lot of stuff to consider, whether it's international or domestic. Where can you refer? You talked about non-profit bodies. Are there good resources that people can go and have a look at to do this homework?
That's a really difficult question, because I suppose if you wanted to do it in the kind of the Rolls-Royce way, it would be, I think, initially speaking to a lawyer in that jurisdiction and to satisfy yourself about what's going to be happening. And again, it kind of comes back to the earlier point of like people's judgment can sometimes be clouded, or they can have priorities in the wrong way, and the main goal or ambition being to get their child. But I would have thought the first port of call would be speaking to specialists in that jurisdiction to work out what's happening. Because if it's a new/emerging market, then people here might not have less experience of it. I mean, there are various online fora that people might go into, but I think that sometimes you have to be quite cautious about that, because you don't know who's holding themselves out as an expert. I would have thought, if you're going through not-for-profit organisations in this jurisdiction, you're going to be fine. But if it's completely new and you're doing it on your own, you need to be speaking to experts in that jurisdiction, because I don't know what the law is in X country, and I can tell you kind of broadly what the kind of procedure is in California, because I do those cases all the time. I was there for a period. But if you're going to a new jurisdiction, they need to immerse themselves there, because that's where they're going to have to be operating to work out how to get back here. Because one of the other things which your earlier question about what they need to think about is that what happens if the surrogate delivers early and the child is in neonatal intensive care unit? What happens with that? What happens with the medical side of things? How does insurance work? All those kind of things are then sometimes not thought about. And then, of course, you've got a situation whereby you're having to fly to X country 12 weeks earlier rather than 39 or 40 weeks. So those things have to be really thought about. And what are your living arrangements going to be in that jurisdiction if you're stuck there for 3 months? I've had cases where I had one case, this is obviously before the war, where the individual was effectively stuck in that particular country for 6 months before they could get a travel document from the UK passport authority before they could come here. So those things have to be really thought about carefully, because you can't replicate those first 6 months with your child. And if your plan is to have the support of your family and friends back home, but you're effectively stranded or stuck in limbo in X country. That's not what nobody wants that. So it's all about doing due diligence. And I would have thought starting off would be assessing and exploring with experts on the ground about what these things are, and having these questions to hand about how do I get recognition, and then how do I get a passport. That might require speaking to an immigration lawyer here in this jurisdiction, because that could be quite difficult.
Yeah, I would agree. The only thing I would add to that as well is that if you're going to be getting legal advice abroad, particularly in one of these emerging jurisdictions, make sure it's independent. Make sure that you're speaking to somebody on the ground and you're not just being referred by a clinic or somebody that you've been speaking to in relation to the surrogacy arrangement abroad. You want to be talking to a local lawyer who deals with this, in this area, to make sure that what you're doing over there is being done properly and it's legal.
Yeah, I couldn't agree more. Couldn't agree more.
Great, thank you, Andrew. I guess just to reiterate something we said earlier, in that we've been talking about quite a few of the pitfalls for surrogacy here, and some of the sort of doomsday worst case scenarios. And just to remind you that for the vast majority of people, surrogacy arrangements really do go through without a hitch whatsoever. These do tend to be arrangements that are well thought through. Lots of time and effort has been put into them. Relationships are often built. So yeah, for the vast majority of people, surrogacy is a beautiful thing that goes through without a hitch. But I guess a good place to end today would be just for you to give us, Andrew, perhaps some of your top tips for anybody that's perhaps just considering going down the surrogacy journey right now, whether that's domestic or international.
I think due diligence is the kind of my take-home phrase of making sure you've done your research about everything, really, about where the country you're going to, if it's international, and how they match you with a surrogate, and understanding what the procedures will be during the pregnancy and post-birth, so that there's an expectation about what's going to happen at the end to get your parental order. I think, as I already touched on, getting advice, if it's an international case, getting advice in that jurisdiction is absolutely vital. There was a judgment a few years ago where one of the High Court judges said it explicitly, actually, that it's really important to think about getting advice in that jurisdiction as well as this jurisdiction. Again, I think it's really important, as you said, not to put people off to say that this is all these cases we're talking about sound quite doom and gloomy, but actually the majority go through fine. But I think people have to have a kind of a really good understanding of things when they're out there. That's in the international cases. In the domestic cases, there tend to be fewer problems because most people tend to go through one of the not-for-profits. The other circumstance, there are two other routes domestically, which tend to be either informal arrangements that are often done by social media, which present obvious problems. And then, of course, family members. So, the classic is, a sister or family member or friend carrying the child. And I think in the latter circumstances, where it's a family member, for example, it's kind of having an understanding of everybody knowing where they stand, because that's where there can then be some confusion. And I think the cases that tend to end up being reported tend to be the ones where there has been a lack of clarity about what's going to happen. One of the things we haven't really touched on, but I think it's probably also important to bear in mind, is that when a court's making a parental order, it has to look at the child's welfare. And I sometimes find, and it's often with opposite sex couples that this happens, but I sometimes find that there's been a lack of thought given to things like life story work. So part of the welfare assessment in a parental order application requires a parental order reporter, so a person from CAFCAS, i.e. a court social worker for non-lawyers, to do a report about whether they meet the criteria and the child's welfare. And one of those things I'll be looking at is life story work. So, for example, if you have a child who's donor conceived, i.e. one of the parents isn't genetically related to the child, having an understanding of how they're going to deal with that. I think sometimes clients don't necessarily think of that at that point, at the beginning. They only think about it when it's raised by lawyers. So I think being aware of the literature about donor conception and having an understanding of that, because that's something which the parental order reporter is likely to ask you about. So I think that's kind of a one that often probably doesn't really come up, but I think it's important to be on it. And as I say, it's sometimes easier for same-sex male couples because there's an obvious life story there that it's two men. So there's got to be a story about how this child came into being in their care. But with opposite-sex couples, where there can be, as we touched upon earlier, where there can be a trauma of miscarriage, fertility problems, all those things that are really, really difficult to deal with, that it can just be thought, well, actually, this is a cure, and now we've got a child, we don't need to think about it. But I think it's still really important that there's consideration given to it, because it's likely to be something which will be raised. And so having an understanding about what we're going to tell our child about how they came to being is something which needs careful thought and consideration. And it's probably, the sooner couples start thinking about it, the easier it is to kind of think about it when the child arrives. So a slightly drawn out tip, but hopefully it helps.
No, I agree. Like research. I think with everything, front load the information. Do all your research early on, and then that enables you to hopefully have a smooth ride as you can when you're dealing with children and pregnancy and birth and all the rest of it.
Yeah, I mean, the last thing you want, as I said earlier, is the start of your child's life being clouded by additional problems. So the easier you can make it, surely the better.
So that's it for this episode of Stow Talks. Thanks for listening. You can find out more about the work Andrew does at www.4pb.com. If you would like more information on our podcasts, head over to stowtalks.co.uk. And please rate, like, share and review this podcast where you can.